Good evening, everyone. I welcome each one of you to our Advocate on Record Aspirants Academy. Today is our lecture number 21. The topic is very crucial. What is the legal effect of dismissal of special leave petition in limine? So, before going to the topic, it is our regular practice that we recite the preamble because we strongly believe that preamble is our goal and preamble our soul. So therefore, I request each one of you to recite preamble along with me before going to the topic. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Thank you so much, dear friends. Now, let us ask ourselves this question. What is the legal effect of dismissal of special leave petition in limine? That is the question posed to ourselves. And let us try to answer. How are we going to answer these questions? So I want you to travel along with me to explore and find out the right answer for this question. For answering this question, we must understand what is Article 136 of the Constitution of India. Because special leave petition falls under Article 136. That is Chapter 4 under Constitution of India that deals with Union Judiciary. So what does it say? Article 136 has got two clauses. 136 clause 1 and 136 clause 2. 136 clause 1 says, notwithstanding anything contained in this chapter, that is chapter 4, which deals with Union Judiciary, the Supreme Court may in its discretion grant leave to appeal against any judgment, degree, determination, sentence or order passed by any court or tribunal in any matter within the territory of India. So meaning thereby, it does not say that appeal lies to the Supreme Court from only judgment. It says any judgment, any order, be it interim order or it may be a final order also, passed by any court. It doesn't use that any court means high court. No, any court or any tribunal, we can come directly to the Honorable Supreme Court by seeking the permission, leave to appeal against such orders. So what does it mean? Why such a wide power vested with the Honorable Supreme Court? Reason is, it is the highest court of the land. And judges, those who are sitting and exercising Article 136, they are experienced people. Their wisdom, their knowledge, their experience, their integrity will help us to get justice to the litigants at large. So therefore, they have given ample power to the Supreme Court under Article 136. This wide power. In some judgments, they have used specifically when there is a chase when somebody is chasing towards injustice, their power is the sky, is the power. There is no limit to their power. So it's unlimited power, enormous power vested with the Honorable Supreme Court. Where are the restrictions? There is no restrictions at all. There is no restrictions imposed on the Honorable Supreme Court. It is their wisdom that they have themselves imposed self-restrictions. Because when such a wide power are there, it has to be used very cautiously. It cannot be used generally in all the cases. Unless and until there is a perversity, error apparent on the face of the record, or improper reception or rejection of vital evidence, then there is miscarriage of justice. Therefore, the Honorable Supreme Court will invoke Article 136 to uphold justice, to uphold the majesty of law. So, therefore, dear friends, this is what Article 136 Clause 1 says. What is Article 136 Clause 2 says? It is an exceptional clause to Clause 1, because Clause 2 says that any order or any judgment, any sentence passed by any court or tribunal constituted under law related to armed forces, they cannot file special leave petition. Therefore, 136 Clause 2 is an exception to 136 Clause 1. So, this is what the overview of Article 136. Now, moving on to the question that I have asked, what is the legal effect of dismissal of special leave petition in limine? Let us understand what is the topic first. We can understand what is special leave petition means. That means an aggrieved person who has lost his case in the Honorable High Court or in any other court or tribunal, he wants to seek the redressal of his grievance before the Supreme Court under Article 136. Therefore, he is seeking special leave to appeal against such impugned order. Why we are seeking leave? Why are we seeking the permission from the Honorable Supreme Court? The reason is, it is not a matter of right to the litigant to invoke Article 136. So, what is that? It is a discretionary power vested with the Supreme Court. So, you have to seek or invoke their discretionary power. So, therefore, dear friends, we understand what is special leave petition. What is the dismissal in limine? If you look at the common meaning of limine, in limine, that means at the threshold, even at the admission stage itself. So, when we file special leave petition before the Honorable Supreme Court, it comes up for hearing for admission. At times, the Honorable Supreme Court hears the learned counsel on behalf of the petitioner. After hearing, they will say it is dismissed. In one line, they say it is dismissed. So, this is what the order is: dismissal in limine. No discussion on the merits of the case, no recording of reasons made by the counsels. So, it is one line dismissal. So, therefore, SLP is not even heard. It is dismissed at the threshold. So, what is the effect of it? What is the meaning of it? The meaning is, whether have they upheld the order passed by the High Court, which is under challenge? We should ask the next question to ourselves. So, when an order is under challenge before the Supreme Court, when such SLP is dismissed, are they certifying, or the Honorable Supreme Court certifying that the High Court order is correct? The answer is no. They are not certifying the High Court order whether it is correct or wrong. They are simply dismissing the SLP. It means that it is not a fit case to invoke our discretionary power under Article 136. Meaning thereby that we don't want to exercise our discretionary power in this case, therefore it is dismissed. So, therefore, legal effect of dismissal of special leave petition in limine means that the Honorable Supreme Court, in its wisdom, did not want to interfere in this case. They don't want to exercise their discretionary power under Article 136. This is what the legal effect of dismissal of SLP in limine means. Hope it is clear. To understand in a more effective manner, I would like to recite one judgment, very, very pertinent judgment. Please take note of the judgment. 1986, volume 4, Supreme Court cases, page number 146. 1986, volume 4, Supreme Court cases, page number 146. The name of the case is Indian Oil Corporation Limited. Indian Oil Corporation Limited versus State of Bihar and others. I repeat, Indian Oil Corporation Limited versus State of Bihar and others. So this was a judgment composing of two honorable judges, Honorable Justice V. Balakrishna Yaradi and Honorable Justice M. Dutt. These are the two honorable judges who decided this case. Before taking you to the relevant portions, relevant paragraphs in the judgment, it is my duty to explain what is the facts of the case. The facts of the case is most important. Reason is, when there is a law laid down by the Honorable Supreme Court, it emerges from the facts of the case. When we take care of the facts, facts will take care of the law. So what is the facts in this case? Indian Oil Corporation has appointed a sales officer. Sales officer was appointed, but he was dismissed after a couple of years because of his misconduct. Now the employee is aggrieved because he was dismissed from service on the charge of misconduct. Therefore, he goes to the labor court. He knocks the doors of the labor court for reinstatement, that I have not committed any misconduct. Therefore, I need to be appointed in Indian Oil Corporation. That was his prayer before the labor court. Labor court, after hearing the Indian Oil Corporation and the employee, award was passed that dismissal of employee by Indian Oil Corporation is wrong. It is erroneous. Therefore, that employee has to be reinstated immediately. That was the award passed by the labor court. Now, who is aggrieved? Indian Oil Corporation is aggrieved. But instead of preferring an appeal, they have executed, they have appointed him. Reinstatement was done. But still, the employee is not happy. Reason is, after his dismissal, his juniors were promoted to the next level. And there was increase. So therefore, he was unable to get the promotion, number one, that is his grievance. And second grievance is, he is unable to get the higher pay scale. So therefore, he made a request, the employee made a request to the Indian Oil Corporation by saying, you should also promote me as that of the juniors, and whatever the juniors getting the pay scale, you should give me that pay scale. So this was the two contentions put forth before Indian Oil Corporation. Indian Oil Corporation did not accept his request. Therefore, the matter again went to the labor court. An award was passed saying that he must be promoted and higher pay scale has to be paid. This was the award passed by the labor court. Now, Indian Oil Corporation is aggrieved. Instead of approaching the High Court, there is a twist here, dear friends. I want you to pay attention here. After labor court, the Indian Oil Corporation did not approach the High Court. Instead, they directly approached the Supreme Court under Article 136. It was dismissed. It was dismissed in limine. That means before granting leave, they have dismissed in single word that it is SLP is dismissed. Now, Indian Oil Corporation was not satisfied with the dismissal order. So they again, Indian Oil Corporation, instead of executing the labor court's award, they went to the High Court and preferred a writ petition under Article 226 with the prayer that the award passed by the labor court must be quashed. This was the prayer by Indian Oil Corporation. On hearing the writ petition filed by Indian Oil Corporation, the Honorable High Court granted stay of the operation of the award passed by the labor court. Now he is aggrieved, the employee is aggrieved. Now the employee prefers an appeal, special leave petition against the grant of interim order. So he is approaching the Supreme Court under Article 136 against the grant of impugned or grant of interim stay. Now the Honorable Supreme Court again dismisses the matter, SLP, saying that let the Honorable Supreme Court hear the writ petition fully within 4 months. That was the time stipulation given. Now again the matter is before the Honorable High Court for adjudication of writ petition. What is the prayer before the Honorable High Court by Indian Oil Corporation? To quash the award passed by the Labour Court. That was the main prayer. There the employee takes out the maintainability of Article 226. What is his objection? Employee's objection is, after dismissal of SLP by the apex court, highest court of the land, how the Honorable High Court can entertain Article 226. So it amounts to violation of the judicial discipline. So therefore, dismissal of special leave petition in limine will bar or will put restriction on Indian Oil Corporation from filing any cases. So that was the objection taken by the employee as to the maintainability of writ petition. Now the Honorable High Court was convinced with the question of maintainability. So therefore, they have dismissed writ petition filed by Indian Oil Corporation on 2 grounds. The first ground by the Honorable High Court was they have applied doctrine of election. What is doctrine of election? The Honorable High Court has held that instead of approaching the High Court, the Indian Oil Corporation approached the Supreme Court. Therefore, they have chosen the upper forum. They have elected the upper forum. So, therefore, they cannot file 226. That is the first objection. The second objection is Article 226. It is a writ jurisdiction and it is a discretionary power vested with the High Court. So, therefore, we don't want to exercise our discretionary power in this case. So, these are the 2 grounds based on which the writ petition was dismissed. Now, who is aggrieved? Indian Oil Corporation, again it is aggrieved. So, they come to the Supreme Court, dear friends. They come to the Supreme Court and they filed special leave petition. Now, the question before the Honorable Supreme Court was this: whether the dismissal of special leave petition in limine earlier will be a bar on Indian Oil Corporation from instituting any remedy like 226 of the Constitution of India or not. So that was the issue. But Honorable Supreme Court has held in this case, mere dismissal of special leave petition in limine will not operate as a bar on the petitioner from initiating any writ jurisdictions. So therefore, the petitioner has got a right to file a writ petition under Article 226. So therefore, they have again remanded the matter to the Honorable High Court to decide the case on merits within the time stipulation. So what is the law that they have laid down, dear friends? The law laid down by the Honorable Supreme Court in this case is that dismissal of special leave petition in limine will not bar the petitioner from filing either review or 226 writ petition or any other remedy. It is merely says, the Honorable Supreme Court merely has said that this is not a fit case to invoke our discretionary power. Therefore, we are not interfering in this case. That's all. Whether if he has got a remedy under 226, let him file it. If he has got a remedy under review petition, he can file it. Or if he want to approach any other statutory authorities, he can do that. So there is no bar at all. So this is what the Honorable Supreme Court has held, and I would like to take you to certain relevant paragraphs, dear friends. Para 6 of this judgment, the question is, the short question that arises for decision in this appeal by special leave is whether the dismissal in limine of a special leave petition filed before this court by a party challenging the award of a labor court would preclude the said party from subsequently approaching the High Court under Article 226 of the Constitution seeking to set aside the said award. So whether is there any bar after dismissal of SLP, can he file writ petition under Article 226? That is the issue. What is the answer here? The Honorable Supreme Court has given findings in para 6. We are clearly of the opinion that the view taken by the High Court was not right, and that the High Court should have gone into the merits of the writ petition without dismissing it on the preliminary ground. As observed by this court in Workmen versus Board of Trustees of the Cochin Port Trust, the effect of non-speaking order of dismissal of a special leave petition without anything more indicating the grounds or reasons of its dismissal must, by necessary implication, be taken to be that this court had decided only that it was not a fit case where special leave should be granted. This conclusion may have been reached by this court due to several reasons. When the order passed by this court was not a speaking one, it is not correct to assume that this court had necessarily decided implicitly all the questions in relation to the merits of the award, which was under challenge before this court in the special leave petition. A writ proceeding is wholly different and distinct proceeding. Questions which can be said to have been decided by this court expressly, implicitly, or even constructively while dismissing the special leave petition cannot, of course, be reopened in a subsequent writ proceeding before the High Court, but neither on the principle of res judicata nor on any principle of public policy analogous thereto would the order of this court dismissing the special leave petition operate to bar the trial of identical issues in a separate proceeding, namely the writ proceeding before the High Court, merely on the basis of an uncertain assumption that the issues must have been decided by this court, at least by implication. It is not correct or safe to extend the principle of res judicata or constructive res judicata to such an extent so as to found it on mere guesswork. So therefore, the Honorable Supreme Court has held there is no bar at all. Therefore, the Honorable High Court dismissing the writ petition even on the ground of maintainability, that is wrong. Further, the Honorable Supreme Court in para 8, it has held it is not the policy of this court to entertain special leave petitions and grant leave under Article 136 of the Constitution, save in those cases where some substantial question of law of general or public importance is involved. Dear friends, here the Honorable Supreme Court has held that under what circumstances that they will interfere, they will grant special leave. I repeat, it is not the policy of this court. Generally, they do not interfere under Article 136. Generally, they say we will not interfere while admitting the special leave petition. We will not grant leave. That is a general rule. But the exception is under what circumstances they will grant leave? When some substantial question of law of general or public importance is involved, or there is manifest injustice. When there is injustice is apparent on the face of the record, manifest injustice resulting from the impugned order or judgment, the dismissal of special leave petition in limine by a non-speaking order does not therefore justify any inference that by necessary implication the contentions raised in the special leave petition on the merits of the case have been rejected by this court. It may also be observed that having regard to the very heavy backlog of work in this court and the necessity to restrict the intake of fresh cases by strictly following the criteria aforementioned. It has very often been the practice of this court to grant special leave in cases where the party cannot claim effective relief by approaching the concerned High Court under 226 of the Constitution. In such cases also, the special leave petitions are quite often dismissed only by passing a non-speaking order, especially in view of the rulings already given by this court in the two decisions aforesaid cited, that such dismissal of special leave petition, here they are laying down a law, that such dismissal of a special leave petition will not preclude the party from moving the High Court for seeking relief under Article 226 of the Constitution. In such cases, it would work extreme hardship and injustice if the High Court were to close its doors to the petitioners and refuse him relief under Article 226 of the Constitution on the sole ground of dismissal of special leave petition. Now, para 10, dear friends, thus the correct legal position is that dismissal by this court, that is the Honorable Supreme Court, of the special leave by non-speaking order of this court did not operate as rejudicator, did not operate as a bar against the appellant in the matter of challenging the impugned award of the Labour Court by resort to proceedings before the High Court under Article 226 of the Constitution. Finally, the Honorable Supreme Court has held, in light of the aforesaid discussion, we allow this appeal filed by Indian Oil Corporation, set aside the order of the High Court. That means High Court which has said that it is not maintainable, that order is set aside, and remand the writ petition to the High Court for disposal of the merits. Having regard to the fact that the case concerns the service benefits claimed by respondent number 3, the High Court is requested to dispose of the writ petition as early as possible. The parties will bear their respective cost. So from this judgment, the Honorable Supreme Court categorically held dismissal of a special leave petition in limine, that means at threshold, without any speaking order. It only says that it is not a fit case to invoke the Honorable Supreme Court's discretionary power. It does not certify that whether High Court order is correct or wrong. So therefore, it will not bar the petitioner from approaching the Honorable High Court for filing a review petition, for filing a writ petition, or any other statutory remedies that he has got. He can exhaust those remedies. That is the law laid down in this case. Now, this was the case decided in 1986. Subsequently, 2000, Volume 6 SEC, this is the second case, a leading case. 2000, Volume 6 Supreme Court cases 359. I repeat, dear friends, 2000, Volume 6 Supreme Court cases, page number 359. This is a case comprising of 3 honorable justices: Honorable Justice K.T. Thomas, Honorable Justice D.P. Mohapatra, and Honorable Justice R.C. Lahoti. Name of the case is Kunnaya Ahmed and others versus State of Kerala. So in this case, what is the law laid down? Still it is holding the field. Even latest judgment 2019, Code 8 Distilleries, the Honorable Supreme Court has reaffirmed, has followed and reiterated the principles laid down in Kunnaya Ahmed case. So I am going to read the principles alone, dear friends, here. See, in para 44 of the judgment, para 44, they have summed up the conclusions. I am going to deal only with the relevant portions. Para 44, Roman letter 4. An order, now they are going to, let me explain first and then let me read. So now let us take it forward. A special leave petition is filed. It is coming up for hearing. It is dismissed in one line. It is dismissed. SLP dismissed. We have seen the effect. What is the effect? Dismissal means it is meaning is that the Honorable Supreme Court do not want to exercise their discretionary power and remedy else lies elsewhere. They can approach there. This is one category. We can divide under two category, dear friends. One is before granting leave, another category is leave granted. So under before granting leave, one is dismissal by a non-speaking order. Another one is dismissal by a speaking order. For example, the Honorable Supreme Court dismisses the special leave petition, but they give certain findings. The party's conduct is not good before the court. They have suppressed material facts. In so and so case, the Honorable Supreme Court in catena of judgments, we have held that a person who approaches the court with unclean hands, with suppression of facts, and that such person is not entitled to any relief, be it interim relief or final relief. They are not entitled to be heard on merits also. This is the law that we have laid down when a person approaches the court with unclean hands, with suppression of material facts. In case if a SLP is dismissed with certain findings that a party conduct is not good and they have referred to some judgments. So what is the effect of dismissal of SLP with a speaking order? The effect is this, dear friends. The effect is whatever the law that they have laid down or whatever the law that they have discussed, that will have a enforcing effect under Article 141. That is binding effect on all the courts. Right? So it has a force of, it will come within any law or any legal statement made by the Honorable Supreme Court in the order dismissing special leave petition. It has the force of binding effect under Article 141 of the Constitution of India. What about the some observations made against the parties? That also binds, right? But there is no doctrine of merger. The High Court order will not get merged with the order of the Supreme Court. I will explain you what is doctrine of merger also. So this is before granting leave. After granting leave, what happens? Very crucial aspects. After granting leave, SLP civil becomes civil appeal. SLP criminal will become criminal appeal. So it takes the effect of discretionary power. When it is still under SLP civil, we are seeking the permission, leave to be granted. So it is a discretionary power vested with the Honorable Supreme Court either to grant leave or not to grant leave. That is their discretion. Once leave is granted, their discretion becomes the appellate jurisdiction. So therefore, when leave granted, SLP civil becomes civil appeal, then there is a bar for the petitioner from filing any review petition or writ petition or any other remedy. He cannot do that because leave is granted. The Honorable Supreme Court is going to exercise its appellate jurisdiction. Is it clear, dear friends? Now what about the merger, doctrine of merger? After granting leave, the Honorable Supreme Court may say High Court order is correct. That is one possibility. Therefore, they are affirming or confirming the order of the High Court, or reversing, setting aside the order, or modifying to certain extent. So whether reversal or modification or affirmation, then Supreme Court order will prevail. So doctrine of merger means, for example, High Court order is passed. Unless and until the operation of the order is stayed, it continues to operate. Once the special leave is granted and the Honorable Supreme Court has given a judgment, that means what is the effect of, for example, the Honorable Supreme Court has set aside the order of the High Court. So now a layman might ask us, sir, here is the High Court order. asking me to be in service. Now the Supreme Court has said that I am dismissed. So which order will prevail? For lawyer like us, we will tell, see, this High Court order was under challenge before the Supreme Court. Now the Supreme Court has dismissed you. Now you have to go home because Supreme Court order will prevail over the High Court order. But he will say, then what is the effect of this order? No, no, this has nullity. High Court order is nullity because it is nullified. It is set aside. So therefore, this High Court order lost its significance, lost its identity. High Court order got merged with the Supreme Court order. This is what the doctrine of merger is. Doctrine of merger is sinking, merging, losing its identity, losing its significance. That is what the merger is. Trial court order is passed. For example, it is decreed in favor of the landlord. Landlord is entitled for the possession and tenant has to get evicted. So landlord got a favorable order. Trial court. Now who is aggrieved? Tenant is aggrieved. Tenant goes to the High Court by first appeal. Now tenant, he is a bona fide occupier. Therefore, let him occupy. There is no default in the rent. So therefore, tenant should not be evicted. So landlord is affected. Now he comes to us because we are in AOR. AOR is the authorized person to file SLP. So he comes to an AOR showing two judgments. One is trial court judgment and High Court judgment. Now talking about the doctrine of merger, the High Court trial court order is nullity. Reason is it was set aside by the High Court. So the trial court's judgment got merged with the High Court order. So trial court judgment is nullity, lost its identity, lost its significance. So this is for sinking, merging with. This is what doctrine of merger is. Now coming to dismissal of special leave petition in limine. That means doctrine of merger does not apply. Reason is they simply say it is our discretionary power, we do not want to interfere, that's all. But after granting leave, that means SLP civil has become civil appeal. So after granting leave, so the petitioner has no remedy to approach any court. And moreover, whatever the affirmation, reversal or modification done by the Honorable Supreme Court, the doctrine of merger applies. Hope it is clear, dear friends. Now let me read the summing up in Kunnai Ahmad case. An order, now it will be very clear when I read this. An order refusing special leave to appeal may be a non-speaking order, one line dismissal, or a speaking one, we are dismissing because they are giving some reasons. In either case, it does not attract doctrine of merger. An order refusing special leave to appeal does not stand substituted in place of the order under challenge. All that it means is that the court was not inclined to exercise its discretion so as to allow the appeal being filed. So in this para, what do they say? Dismissal of SLP either by a speaking order or by a non-speaking order. In both the cases, the High Court order will remain same and effective and no question of merger. 5. If the order refusing to appeal is a speaking order, now the yet another option, before granting leave but dismissing the case with reasons. If the order refusing leave to appeal is a speaking order, that is, gives reasons for refusing the grant of leave, then the order has two implications. When it is a speaking order, it has two implications. What are they? Firstly, the statement of law contained in the order is a declaration of law by the Supreme Court within the meaning of Article 141 of the Constitution. So therefore, any legal finding with respect to in the dismissal of SLP It has a effect under Article 141, binding effect. Secondly, what is the second implication? Secondly, other than the declaration of law, whatever is stated in the order or the findings recorded by the Supreme Court, which would bind the parties thereto, and also the court, tribunal, or other authority in any proceedings subsequent thereto by way of judicial discipline, the Supreme Court being the apex court of the country. But this does not amount to saying that the order of the court, tribunal, or other authority below has stood merged in the order of the Supreme Court rejecting the special leave petition, or that the order of the Supreme Court is the only order binding as res judicata in the subsequent proceedings between the parties. So when a SLP is dismissed with speaking order, it has got two implications. What are the two implications? Firstly, they say any law laid down while dismissing the special leave petition, it has a binding effect under Article 141 of the Constitution, number one. Number two, once it is declared and there are certain findings of facts with respect to the parties, it binds on the parties also. It binds on the courts below also. But there is no question of merger. Next, we are moving on to the next point. Now, this is after granting leave granted. Once leave to appeal has been granted, an appellate jurisdiction of Supreme Court has been invoked, an order passed in appeal would attract the doctrine of merger. The order may be of reversal, modification, or merely affirmation. So once leave is granted, then the merger takes place. The order of the High Court gets merged with the order of the Supreme Court. Next, on an appeal having been preferred, or a petition seeking leave to appeal having been converted into appeal, from specially petition having been converted into appeal, what happens? Before the Supreme Court, the jurisdiction of the High Court to entertain a review petition is lost. Thereafter, as provided by Sub-Rule 1 of Rule 1 of Order 47, once leave granted, SLP becomes civil appeal, then the petitioner loses his right from filing any petitions before the High Court. So this is what Kunya Ahmed case is held in this case, and it is further reiterated. I'll just give you the citations alone, dear friends. Still, this principle, this law holds the field. Further, it is reiterated in the latest judgment, 2019, Volume 4, Supreme Court Cases, page number 376. I repeat, 2019, Volume 4, Supreme Court Cases, page number 376. What is the name of the case? Code Distilleries Limited. Code Distilleries Limited versus Sri Mahadeshwara. Sri Mahadeshwara. And it is a long name, dear friends. This is sufficient. 2019, Volume 4, SEC 376. In this case also, they have reiterated and followed what was the law laid down in Kunya Ahmed case. Now, from this, what we have learnt is, what is the legal effect of dismissal of special leave petition in limine? Before granting leave with a non-speaking order, granting leave with a speaking order, and after granting leave, once leave is granted, when special leave petition takes the birth of civil appeal, then the petitioner ceases his right to approach the High Court. So with this, dear friends, hope we have answered our question with the cited cases. Thank you so much for your patience hearing. Thank you so much.